Good morning, and thank you for joining the webinar. My name is Philip Kruger, and I'm a director in the legal department of RSM South Africa, based in Johannesburg. Today, we're going to be discussing the Companies Act Amendment Acts and highlighting the pertinent changes in the legislation. Unfortunately, we're not going to be able to cover every single amendment in detail, but I do intend to highlight the amendments most likely to affect companies and boards on a day-to-day basis. Now, from an introductory point of view, why was there changes to the Companies Act 71 of 2008? Well, as we can see, more than a decade has passed since the commencement of the Companies Act, and certainly a lot has changed. We've been through two iterations of the King Report on Good Corporate Governance, with significant amendments brought on by King 4, particularly then looking at the areas of directors' liability and disclosure of remuneration. And the third iteration, being King 5, has indeed also been published on 31 October 2025 and will also then be effective from 1 January 2026. So against this moving backdrop, compliance requirements has certainly become extremely difficult to navigate, and the cost of compliance administration has become a significant burden. The Companies Act itself has also shown inefficiencies in practice, and in particular, if one look at the requirements in respect of intercompany loans, it has led to quite a lot of administrative burden. As such, 14 years on, amendments to the current position had to be made. Now, this has resulted in two amendment acts being signed into law and being published in the Government Gazette. Although the amendment acts have been signed into law, and for the most part, they have become effective on 27 December 2024, there are still provisions which are not in effect yet. These are really then limited to provisions which require further clarification in the new regulations to be issued, which we have not been given a date yet as to when these new regulations will be issued. I will, however, during the course of this presentation, point out to you where sections are in force yet and where they are not in force yet. So with that background then in mind, the objectives of the Amendments Act have been stated to be as follows: to enhance transparency and disclosure requirements, to the extent that time bars for making an application to declare a director to be a delinquent director, that has been extended, to extend periods under which directors can be held liable for damages and loss, then also to reduce administration and compliance burdens, and then lastly, clarification of technical terms and general cleanup of wordings that was problematic in certain sections. Looking at the application, as one would expect to see, it applies all throughout, all types of companies, looking at public companies, state-owned companies, private companies, not-for-profit companies, as well as close corporations. So as one would expect, it ties in all forms of entities. Starting then with our first set of amendments. Now, the first amendments relate to really just new definitions included in the Companies Act. And in my view, none of these bring about dramatic intervention. One can see, for instance, a definition of the Broad-Based Black Economic Empowerment Act has been included, as well as then a definition of the BEE Commission and BEE Commissioner. But then notably, though, the definition of securities has indeed been amended, deleting a previous vague reference to any other instruments that was included in the initial definition. And that inclusion, to my mind, to a large degree, made the previous definition quite clumsy and led to a lot of uncertainty as to what exactly is defined. So in my view, the deletion of that wording is certainly a welcome amendment. And it's to be noted that the amendment to securities in particular has been effective since 27 December 2024. Now, the first real amendment then of substance comes in the form of Section 69B of the Companies Act. And in this regard, previously uncertainty reigned absolutely supreme in respect of the meaning of the word filed, particularly as to when an MOI amendment would take effect. Now, this uncertainty was there despite the word file having been defined in the Act. However, arguments around that definition and interpretations reigned from whether it would be the date on which this document has been received by SIPSI or the date that SIPSI actually applied its mind to the document. But ultimately, unless a specific date was inserted into the notice of amendment, there was no absolute certainty as to when an MOI amendment would indeed be effective from. The amendment to Section 169B, however, sufficiently clarifies this position. It states very clearly that an amendment to an MOI is effective 10 business days after the receipt of the notice of amendment by SIPSI, unless it is approved or rejected by SIPSI prior to the expiry of the 10-day business period, or such later date as set out in the notice of amendment. So it's either going to be within the 10-day period or as per the notice of amendment. In addition, then, if rejected within this 10-day period, SIPSI is required to provide clear reasons as to why the MOI was rejected. That results, in my mind at least, in even more clarity with regards to MOI amendments. So from that point of view, certainly in my mind, it's a welcome addition to the section. And it's also to be noted that this amendment is now effective and has been so effective since 27 December 2024. The next amendment relates to Section 25 of the Companies Act. Now, the previous Section 25(3) required that a company file a notice detailing the location at which the company records are held and that it should be accessible there. If it is different from the company's general registered address. The new requirement, however, in addition to filing this notice, places an obligation on SIPSI to publish such a notice as prescribed. Now, how this publication will take place, or when really for that matter, we can only really guess whether it would be in newspapers, on a website. No indication has been given. Therefore, in this regard, we still await clarity to be provided by SIPSI. The section is then not yet effective and is one of the sections that is pending further clarification. And we hope that we will find that clarification once the new regulations will be finalized. Then our next amendment comes in the form of Section 26, which constitutes quite a significant departure from the previous position under the Act. However, firstly, there is an amendment to Section 26(1), which relate mostly to clarity of wording. This clarity of wording providing that shareholders or persons that have a beneficial interest have the right to request annual financial statements as a separate subclause in the Act, as opposed to what was previously a combined provision. In addition, then there's a new Section 21F, which is included in the amendment, and that provides the right to inspect and copy the beneficial interest disclosure registered by shareholders by persons who have a beneficial interest. However, then we get to Section 26(2), and this is where the significant departure comes in. Section 26(2) provides a more significant amendment. And for the sake of clarity, Section 26(2) relates to persons who are not shareholders or persons who hold a beneficial interest in the company. Therefore, it relates to third parties. Previously, such persons had a right to request access to the MOI, which is a public document in any event, the share register, and the register of directors. However, now this list has been expanded on, and the amendment in Section 26(2) now adds to that list to include the right to request access to the annual financial statements and register of beneficial ownership, bearing in mind that this relates to third parties. Now, in the light of the recommendations of the Financial Action Task Force and the recently lifted grey listing of South Africa, it might make sense to include access to beneficial ownership, the beneficial ownership register, to third parties, particularly given SIPC's request for registration of beneficial ownership in entities. However, the right to request access to the annual financial statements seems to be quite an invasive step by the legislature. To this end, therefore, the legislature did insert a qualifying provision limiting the application to the amended Section 26(2). This limitation states that the right to request the annual financial statements does not apply in respect of a private company, a non-profit company, or a personal liability company when such an annual financial statement is either internally prepared in a company with a public interest score of less than 100, or annual financial statements which is independently prepared in a company which has a public interest score of less than 350. However, in respect of entities that has a PI score of 350 or more, the amendment does apply. It's therefore recommended that companies monitor their PI score much more closely to make sure that they don't fall foul of the compliance requirements of Section 26(2). However, the good news is that this section, again, is not effective yet and is still pending finalization in terms of the new regulations. And we hope that the new regulations might shed a little bit more light on how this is going to be implemented. Then coming to the next amendment, which is Section 30. Now, the amendment to Section 30 finally confirms the interpretation that SIPC, IRBA, and most of the audit firms have held in respect of disclosure requirements relating to directors and prescribed officers. The amended section now states the following: remuneration, as defined in subsection 6, must be disclosed, and the benefits received by each individual director and prescribed officer in the company must be disclosed, both of whom must be named. Now, this confirms the position that individual disclosure with the person named in the relevant disclosure in the AFS of the company must take place. There was also a new Section 30 sub 4 added, which excludes certain sections of the so-called Director's Remuneration Report from being subject to an audit. In particular, the sections that are excluded is the background and the company remuneration policy. We will, however, discuss these terms in more detail in Section 30 capital B, which is also a new amendment to the Act. It does serve to be noted, however, that this requirement is limited to public companies and state-owned companies. Similarly, Section 30 capital A is also a new insertion in the Act and is also limited in its application to public companies and state-owned companies. Essentially, this section places an obligation on these companies to prepare and present for approval a so-called remuneration policy to shareholders at the AGM. Such a remuneration policy must then be approved by the shareholders by way of an ordinary resolution. If it is not so approved, however, it must then be amended and resubmitted to the shareholders at the next AGM or at the next shareholders meeting called specifically for this purpose. Now, if the policy is approved, it remains valid for a 3-year period, and during this 3-year period, it can still be amended. However, any material amendments during this 3-year period will require a new approval by shareholders, again on the basis of an ordinary resolution. Now, in broad conceptual terms, this amendment, in my mind, is aligned with the disclosure requirements that was taken up in King 4. And that's also still retained in the published King 5. However, King 4 only required approval of the remuneration policy of a company on the basis of a non-binding confirmation by the shareholders. The Amendment Acts have now legislated and formalized this requirement insofar as it relates to public companies and state-owned companies by requiring the approval of this policy at the AGM on the basis of an ordinary resolution. Again, then we have a new insertion in the form of Section 30, capital B, and again, this new insertion is limited to public companies and state-owned companies. Now, this section relates to this remuneration report, which is required to be presented to the shareholders. Now, the report must contain the following. It must contain a background statement. Now, that background statement we know is excluded from audit as per Section 30. A copy of the company's remuneration policy. Again, Section 30 excludes that from audit. And then an implementation report. And importantly, the implementation report will be subject to audit. There are also a number of implications that flow for a remunerations committee or the equivalent of such a committee if such a report is not approved by or at the AGM. So due to the limited application of this, we're not going to delve into that repercussions in much detail. However, if you are representing a public company or a state-owned company, I would certainly recommend that the amendment in the form of Section 30B is well worth the read. However, for the sake of time's completion of this presentation, we're not going to look at the detail in this regard. It should, however, be noted that these sections are not yet effective and still pending finalization of the new regulations. So hopefully we will again see a little bit more detail coming out in the regulation as to how this should be implemented and indeed what those statements and inclusions in the report should contain. The next amendment relates to Section 33, particularly then looking at the annual return. And this amendment to Section 33(1)(a) essentially cleans up wording of its predecessor, whilst not really making substantive change to the requirements. The position, as per the previous wording, remains that a company is required by the Act. If a company is required by the Act to be audited, it must submit a copy of its audited annual financial statements with its annual return once it has been duly approved by the directors. Again, this section was not included in the sections becoming effective on 27 December 2024 and is still pending the finalization of the regulations. Why that is not clear to me, particularly because it is such a minor amendment and not really changing substance, but nevertheless, that is the position. Then getting to Section 38, capital A, which relates to irregular issued shares. Now, this sounds like something that that doesn't happen quite often, but I can guarantee you that in practice we come across this position very often. And it essentially deals with a position where the board of a company has issued shares that it was not authorized to issue or that may not have been created in the authorized share capital of the company before such an issue. Now, previously, the Act dealt with it in terms of Section 38 of the Act, and Section 38 remains valid. It remains there. It only gets an additional section in the form of 38A. Now, Section 38, which remains valid, provided for a potential retroactive authorization of such shares within 60 business days. If not retroactively approved by the shareholders of the company, the issue of the shares would then become a nullity. It would then be required the company must return the value that it received for such shares, and the directors, of course, who then authorized such a share issue would be liable as a consequence of such an irregular issue of shares. However, what is clear is that the remedy in Section 38 provided only a remedy to the company, in other words, the board, in the form of an option of approaching the shareholders with a request for ratifying the issue of these unauthorized shares. And this ultimately then left any third party without a remedy. And it also didn't provide for any form of court intervention in this process. And it's in this regard then that the new inclusion in the form of Section 38A of the Act will be a welcome amendment. Section 38A states that where a company creates, allots, or issues shares by virtue of the Act, the MOI of the company, or any other law, and where the creation or allotment of those shares are not in valid terms of those documents, or where these shares were not properly authorized to begin with, a court may, upon the receipt of an application made by either the company or any third party who holds an interest, and after satisfying itself that it's just and equitable to do so, may make an order validating the creation and allotment of these shares, or confirming the terms or the creation or allotment of these shares. Now, this will ultimately then result in a position where, after the payment of all the prescribed fees by the company, the shares will be deemed to have been validly created and allotted and issued upon such conditions as the court may impose. Now, this provides a welcome remedy to third parties, and it's certainly a step in the right direction in terms of the Amendment Act. However, what remains unclear is how Section 38 and Section 38A will interact. So, in other words, bearing in mind that there's this 60-day period within which a board can approach its shareholders to rectify the position retrospectively through ratification. So the question is, can you employ Section 38A or utilize Section 38A as a third party whilst that 60-day period is still running? Or do you have to wait for the expiry of the 60-day period and first see what the board is in fact going to do? And only upon the board's failure to approach shareholders can you then apply to court. The amendments are not really clear on what that process will look like. However, again, worth noting that this is still pending finalization. It has not been made effective yet, and therefore we are hoping to see some more clarification in this regard in the regulations as to when these remedies can actually be utilized and how they will interact with one another. The next section that we'll be looking at in terms of amendment is then, of course, the amended Section 40. Now, Section 40 of the Companies Act, and in particular the amendment here, relates to the uncertainty created by the use of the phrase in the previous section, which was the wording "to be held in trust." Now, how this created confusion is in a position where shares have been issued but not fully paid up yet. The Act required in the previous section that these shares to be issued to a third party must be held in trust and then later transferred in accordance with a trust agreement. Now, this created confusion, particularly around the usage of the word trust, because what the legislature intended was not necessarily for the shares to be physically held in an established trust, but it was rather to be held in a trust relationship. So in other words, to be held in a fiduciary capacity on behalf of someone else. And then that had to be regulated by a so-called trust agreement. But it didn't really refer to the vehicle of a trust to house such shares. However, this led to a lot of confusion, and a lot of people interpret it to physically be a trust that should hold those shares. Now, the new Section 45 sub 5B2 has amended this position and clarified this position. And that then states that such shares to be issued must be transferred to a stakeholder to be held in terms of a stakeholder agreement, and then later transferred to the subscribing party in accordance with such a stakeholder agreement. Now, the usage of the word stakeholder takes away that confusion. And then just to add absolute certainty, there's a new section in the form of Section 46 and 46 capital A, which adds then a further cleanup of the wording. and it defines what a stakeholder is. And it then goes as far as to say it's an independent third party who has no interest in the company or the subscribing party, who may be, for instance, an attorney, a notary public, or an escrow agent. So I don't think the section can be made any clearer. I think it's crystal clear as to what should happen in the event that you are to issue shares that is subject to payment later on. The next section, therefore, oh, it also just on that previous slide, it serves to be noted also that the section is indeed already effective now and has been so effective since 27 December 2024. The next amendment we're going to be looking at is Section 45, which relates to financial assistance. Now, the amendment to Section 45 aims to reduce the administrative requirements in respect of financial assistance provided by a holding company to its subsidiary companies. You'll recall I mentioned that that was one of the inefficiencies that the Companies Act created in the form of the initial Section 45. Now, again, it serves to be noted that this section is effective since 27 December 2024 and therefore already applies. So previously, Section 45 required that any financial assistance to directors, prescribed officers, and related and interrelated companies be approved by a special resolution of shareholders, then be approved by a board resolution applying the solvency and liquidity test. And of course, you had the reporting duty to relevant stakeholders and trade unions, typically being your creditors. Now, this led to a significant administrative burden in scenarios where, for instance, a holding company were to provide a loan or financial assistance to a subsidiary company. The newly inserted Section 45 to capital A now excludes a company of financial assistance to or for the benefit of its subsidiaries from these requirements. So this is certainly welcomed. It's definitely going to make it simpler in that holding company subsidiary company relationship. However, there is one part of this amendment which I think was not properly dealt with in the Act, and that is that at the moment, if we take the definition of subsidiary in terms of Section 1 of the Act as a strict definition, this exclusion at the moment would not extend to foreign subsidiaries and would only extend to local subsidiaries of a holding company in South Africa. I'm not certain that that was the intention of the legislation, but rather an unintended consequence of the definition of subsidiary only relating to South African entities. And we'll have to see how this is going to be dealt with going forward. The next section that we're going to be looking at is Section 48 sub 8. And that intends to amend the approval requirements for a buyback transaction. In particular, then, it makes significant changes to when special resolutions are required before a buyback can be implemented. It also serves to be noted that this section is effective now already and has been so effective since 27 December 2024. So previously, Section 48.8 stated that a special resolution is required to approve the buyback of a company of its own shares from a director or prescribed officer or a person related to them. And in the cases where Section 114 and 115 of the Companies Act applies to a buyback if it involves more than 5% of the issued share capital of the company in any particular class of its shares. In terms of the amended section, though, a special resolution is simply put always required unless one of two circumstances is present. One such exclusion is where such a buyback is made as a pro rata offer by the company to all of the shareholders of the company or all of the shareholders in a particular class of shares, notwithstanding the fact that that pro rata offer made to all shareholders also includes shareholders who are persons that are directors or prescribed officers of the company, or if it is a transaction effected on a recognized stock exchange and on which the shares of the company is traded, that is properly licensed in terms of the Financial Markets Act. Those would be the only two circumstances where a special resolution is not required. In all other circumstances where we have a buyback, we now have to apply a special resolution in order to implement such a transaction. Just some comment on the section itself. I think the wording is slightly problematic in respect of the amendment. It's almost written in the negative form. So it is quite difficult to read the section, but I think the effect of it is certainly welcomed in that it creates certainty when you do structure these transactions, that a special resolution will most likely be required. The next section we'll be looking at relates to shareholder meetings. And in particular, then, we're looking at section 61.8, which has been amended for two additional reports to be included in and presented at the AGM of a company, if indeed the company is required to have an AGM. Of course, we know that most private companies do not have the requirement of an AGM. So previously, what was required to be presented at the AGM would be your director's report, the audited financial statements, and the audit committee report. However, the amended section 61.8 sub A requires still the above, while still adding to that list then a social and ethics committee report and the remuneration report, which we discussed under section 30. So important then also to note that the members of a social and ethics committee must now be appointed at the AGM, similar to an audit committee member as well. So again, I think it's an amendment really just to sort of standardize what should occur in respect of the appointment of those members, and then to include formally the Social and Ethics Committee report and remuneration report to be presented at the AGM. So again, I think it's a welcome amendment, and again, it serves to be noted that the section is effective and has been so effective since 27 December 2024. The next section that has received a significant amendment is section 72, insofar as it relates to the Social and Ethics Committee. So the most important parts of this amendment then really relates to when a company is to apply for the exemption from the requirement to have a social and ethics committee. Previously, that would merely be an application to the company's tribunal. However, now the requirement is that the company must first publish its intention to lodge an application for exemption with the tribunal in the prescribed manner. There has been no detail as to what the prescribed manner will be. So there's no clarity yet as to how and when and in what format the publication needs to be made. But we're hoping to see that in the new regulations that will come out as well. Then, secondly, such an exemption can then still be granted as previously if the company has a formal mechanism within its structures that will substantially perform the same function as a social and ethics committee, or if it's not reasonably necessary having regard to the nature and extent of the activities of the company and having regard to the public interest for such a company to have a social and ethics committee. And again, a social and ethics committee would not be required if the company is a subsidiary of another company that has a social and ethics committee, or that has an existing social and ethics committee that performs the function on behalf of this company. So a lot of that has stayed the same. However, one of the new additions that can be quite problematic going forward is that a new insertion now provides that the minister may prescribe the minimum qualifications and skills and experience requirements for members of the Social and Ethics Committee that he or she may then deem or consider necessary in respect of membership of the committee. This was not previously the case in respect of a Social and Ethics Committee. King 4 made recommendations as to the sort of background or background and skill that these members would have, but it was not formally legislated in the Companies Act. So with the minister now having the entitlement to make these recommendations or to prescribe these minimum qualifications, um, it will certainly make it more difficult for entities to find the right individuals to sit on these committees. Certainly, I think, yes, having the right skills and experience would add value to these committees. But in a market where it is already difficult to find the right individuals to sit on these committees, it might be quite challenging to find people with certain prescribed minimum skill sets and qualifications. Um, so we'll have to see how this plays out. The minister has not yet made any form of determination in this regard. Typically, those determinations would only be made in terms of the new regulations. So we'd have to see what is going to be the content of these new regulations before we can make too much of a meal of this. But it is a potentially problematic section. In the case then of public companies and state-owned companies, the majority of the members must be directors who are not involved in the day-to-day management of the business of the company. Colloquially, we would say it should be non-executive directors and yeah, most likely independent directors. And they must not have been so involved at any time during the previous 3 financial years. The membership requirement for any other companies, so other companies than public companies and SOCs, so in other words, private companies, that membership requirement remains the same, with the requirement being that the members must consist of not less than 3 directors or prescribed officers, at least one of whom must be a director who is not involved in the day-to-day management of the business of the company and must not have been so involved within the previous 3 financial years. Portions of this section is already effective, particularly then relating to the membership requirements. However, the requirement for the minister or the ability for the minister to prescribe the minimum qualification, skills, and experience is not effective yet. So we'll have to wait and see how that plays out. The next section we're going to be looking at is section 90, which relates to the appointment of the auditor of the company. Now, the amended or newly inserted section 91 capital A of the Act reads what was previously, in my mind, an oversight in the Act. Previously, the Act required that a private company, referred to in section 84 of the Act, or a company that is required in terms of its MOI to have its annual financial statements audited, required that the appointment of the auditor must occur at an AGM, which created the impression that these entities would have to have an AGM and a formal AGM in order to make such an appointment. The requirement to have an AGM, however, generally applies to public companies and state-owned companies. Therefore, the previous position created a completely unnecessary requirement for a private company to hold an AGM purely to appoint the auditor. This has now been rectified by the new section 91 capital A, and it states that a company that is referred to in section 84 or is required in terms of its MOI to have its annual financial statements auditor must appoint an auditor at a shareholders meeting at which the requirement first applies to the company and thereafter annually at the shareholders meeting. So therefore taking away the impression that it has to be done at an AGM per se. Furthermore, the previous term of 5 years prohibiting specific parties to act as the auditor of the company has now been reduced to 2 years, and this amendment is certainly then welcomed as well. And it's to be noted that this section is now effective and has been effective since December 2024. The next section that is amended is section 77 relating to the liability of directors. And the Act has the effect that the general prescription period of 3 years, as per the Prescription Act, does not necessarily apply to the liability of a director that may have resulted from some form of omission or loss suffered by a third party or the company. Now, the new section states that, or expressly states that the Prescription Act 68 of 1969 does not apply, that generally such proceedings would not be commenced more than 3 years after the omission that gave rise to the liability. However, and this is the really invasive part of it, is that a court may, on good cause shown, extend the period, regardless of whether or not the prescription period has expired or not. And the court can extend that period to whatever period they would deem to be appropriate. So it really just extends the period during which a director can be held liable, and the director then can't necessarily go back and say, well, it's been 3 years, I shouldn't be held liable for this act anymore. As a third party or whomever the party is that suffered damages can approach a court for an equitable order in this regard. So certainly need to take note of. And essentially, it significantly increases the liability for the directors. So certainly something to be aware of, and this section is already effective and already applies. The next section we'll be looking at is section 162, which relates again to delinquent directors. And it's a similar type of provision to the section 77 amendment. And again, section 162 creates the position where an application can be brought against a director to be declared a delinquent director. And it requiring that they have been such a delinquent director now within a 60 months preceding the application, where previously the period was limited to 24 months. So now it's a 5-year period as opposed to a 2-year period. And to add to this period may be extended even further, again, if a court, on good cause shown, extends the period, regardless of whether that 5-year period has expired or not. So again, just making that period longer during which a director can be declared to be a delinquent director. So again, something to be aware of for directors, again, striking towards possible consequences for directors acting on behalf of the company. And again, well worth noting that this section is currently effective and has been effective since December last year. There are a number of remaining amendments that we're not necessarily going to look at in great detail. And it's purely because these amendments are largely administrative in their application. And they really only apply in limited circumstances. However, in short, it looks at section 95, which relates to public offerings, and in particular, the definition of an employee share scheme has been slightly amended there. And really, it's a cleaning up of the previous wording. Section 118, in respect of the takeover regulations, has also been amended, and there the amendment purely relates to the application of the takeover regulations to a private company, particularly just cleaning up the wording that relates to the threshold as to when it would apply to a private company, and really just it's easing the reading of that section as opposed to necessarily changing the substance of it. Section 135 relating to the business rescue provisions, and it really relates to the treatment of post-commencement finance relating to lease costs. Section 160, it really just relates to disputes concerning name reservations, and it enables administrative orders to be made in this regard. In terms of section 166 relating to alternative dispute resolution, largely just process requirements during such proceedings that have been amended. In terms of section 167, dispute resolution consent orders, again there it's really just a cleanup of the wording employed by the Act. Section 194, the appointment of the company's tribunal. Again, it's a largely administrative amendment just relating as to the terms of the appointment of the company's tribunal. Section 195, the functions of the company's tribunal. Again, it's a largely administrative amendment, nothing of much concern there. And then lastly, Section 204, the functions of the Financial Reporting Standards Council. Just again, a cleanup of wording in that section. It is worth noting, though, that in this regard, Section 135, Section 160, 167, 194, and Section 204 are all currently effective, with the remaining sections then only pending really the publishing of the new regulations. So this brings us to the conclusion of the amendments that are currently effective and to be effective once the regulations have been published. And in general, my feeling about the amendments is that they are generally positive. I do think that most of them clarify a number of interpretational issues that was previously there, and also assists with a lot of the administrative burden, particularly then looking at intercompany loans. There are certain items such as Section 38A, etc., that require some further clarification. And certainly we would need to see that either from SIPSI or the legislator coming through. And in this regard, we await the new regulations. I'm hoping to see that we'll get the necessary clarification in respect of how these sections will be implemented and how we should view them in respect of the regulations. So eagerly awaiting that and hoping to see that publication date soon. There has been no formal announcement as to when the new regulations will be published. There was some mention of it being late in 2025. However, given the timing, there's essentially 2 months left, and there's been no real murmurs of it occurring. So we'll have to wait and see, but I would think it unlikely to happen before the end of the year, unless we have been previously surprised by amendments coming through late in December, or publications coming through late in December. So it may happen. We'll just need to keep an eye on that. And with that, I would like to thank you for your time. I'm just going to see if there has been any questions in the interim. None that I can see. Please do feel free to send any questions through via email. I'm happy to address them, and I will attend to them as soon as I possibly can. Then with that, I'm going to thank you, and we can let you go. Have a great day further. Thank you very much.